where the clock is, so.
Oh, you can't
No.
see it. Tammy's holding one up.
Okay, perfect.
We welcome to the Court of Appeals today. We'll be hearing arguments in Scott versus Benson. Counsel, if you could please enter your appearances for the record.
Ben Lusty on behalf of appellant Sarah Catherine Benson, Your Honor.
Jeremy Jones on behalf of the appellee, Taylor Scott.
And we've already started with some technical difficulties, and we'll do our best to make sure that that doesn't happen. We will, as Lisa mentioned, we'd ask you to mute your camera. So, do you have any questions before we begin?
No, Your Honor.
Perfect. Then with that, Mr. Lusty, please begin anytime you would like.
Thank you, Your Honor, and may it please the court, appellant Sarah Catherine Benson respectfully ask this court to reverse the decision of the district court and hold that appellee Taylor Scott has no legal rights in RJB, the child at issue in this action. There are three principal reasons why this court should reverse. First, Mr. Scott, ex-boyfriend, was never a declarant father, as that term is defined, for two reasons. First, the district court found that the voluntary declaration of paternity, or the VDP, was void ab initio, meaning it never had any legal effect. And also because ex-boyfriend never claimed to be a genetic father, he never had the statutory right or permission to execute the VDP under Section 301. Judge.
Let me, couple of questions there. Never claimed to be a genetic father. I guess I need you to explain then what the box on the VDP means where he says, I believe that I am the biological father of the child. Isn't that a claim that he's the genetic father?
Your Honor, I disagree that that can be properly interpreted to be a claim. The reason is that when he executed it, as the district court found, and which has not been disputed, he knew that he was not the father. He knew that that was untrue. It was, for lack of a better term, a lie, or at least fraudulent at the time it was executed. If this court interprets the word claim to include a knowing falsehood, what we could call perjury, it creates a lot of problems because it would allow parties to fraudulently execute a VDP, which then does create parental rights in circumvention of the Adoption Act. So if we look at the language of the Adoption Act, it provides in Part 6 of the Judicial Code that any adult individual may adopt a child. If you compare that to Section 301 of the Voluntary Declaration of Paternity Act, it says the mother of a child and a male claiming to be the genetic father of a child may execute a VDP. Now, the execution of the VDP has inherently built into it that language because that's put there by the Department of Vital Statistics. If you look at some of the other language of the statute, it says the VDP must be in a form. But if you look at the language of the statute, 301 says those who may sign are the mother and a man who claims to be the genetic father. Now, I think that means that the claim to genetic fatherhood must predate the execution of the VDP. Otherwise, the statute could read, any man who signs a VDP attains the rights of parenthood or the rights of fatherhood as provided in Section 304 and 305.
But the statute itself doesn't require the claim to be a good faith claim. That was a theme that sort of was woven through your brief. And I guess one of the things I'd like to ask you today is where in the statute can I find some indication that this claim has to be made in good faith?
So, Your Honor, I think that it's inbuilt into the language of the statute in a few respects, and if not good faith, at least not fraudulent. And I think that there are several reasons when we look at the context of the statute why that is the case. First of all, the VDP statute presumes that there is a genetic relationship between the father and the child. Now, in most cases, it assumes that that's just as a matter of course going to be the case. It does lay out some provisions on how to address when, in fact, it might not be. But the overall the overall structure of the statute presumes that this is primarily going to be executed by parties who have a belief in genetic fatherhood. As such, it fills a gap. It effectively allows parties to create a fatherhood relationship without going through the steps of the Adoption Act. But if you look at 304 and 305 provides that only a valid VDP creates the relationship. Section 202 provides that only an effective VDP creates the relationship. 301 says that a mother and a man claiming to be the genetic father of a child.
Wasn't this valid and effective for what, a good 2-3 years? I mean, everybody operated under it. He presumably paid whatever child support he was obligated to pay, and he had the rights of fatherhood for the time period's a little vague in my mind, but it was a number of years, right?
It was de facto, in effect, Your Honor. I disagree that it was legally valid because because Mr. Scott, in my mind, did not have the right to execute this VDP, and as the district court found, it was fraudulently executed and found to be void ab initio. So no, Your Honor, it was not effective. It was not valid. It was perhaps creating a de facto situation. But as this court is well aware, de facto custodial parental relationships arise all the time. That doesn't necessarily mean that they're protected in law just because that they exist de facto.
Well, let me ask you about the void ab initio issue, because that does seem to be a real linchpin of your argument. And I guess I'm not sure where Judge McKelvey came up with void ab initio. I haven't yet read the trial briefs that were put in front of him, and maybe people were asking him to do that. But there doesn't seem to be anything in the statute that compels that result. Can you give me some shed light on the question of why he chose that term and what his basis was for choosing it?
So, Your Honor, as best I can tell, reading the Judge McKelvey's opinion and from my understanding of the statute at large, the void ab initio comes from the fact that the VDP was fraudulently executed. There's not specifically language in Part 3, or for that matter, in the Act that I find that says, an instrument can be deemed to be void ab initio. However, I think the district court said, this is a fraudulent document. There was a fraud perpetuated on the Department of Vital Statistics, and the court is going to hold it as void ab initio of no effect. And I think that does comport, Your Honor, with the larger language of the statute, which says a man who claims to be the father of a child may execute a VDP. It doesn't say may assert his claim by executing a VDP or through executing a VDP, nor does it say that the execution of a VDP is evidence of his claim to be the genetic father of the child. There's two, on the one hand, execution of the VDP and claim to genetic fatherhood, and they're joined by a conjunctive in 301, which I think is significant, meaning we don't just want someone to sign a VDP of whatever mental state vis-a-vis the representation of genetic paternity, and thereby gain legal parentage of the child. Yes, Your Honor.
But aren't there two parts of the statute that anticipate what will happen if something is fraudulently executed? I mean, a declaration is fraudulently executed. I mean, we've got 302 that addresses what happens when someone falsely declares the existence of a presumed declarant or adjudicated father. And then we've got 307 that does allow for a challenge to be brought on the basis of fraud. So, it does seem to me that while I appreciate from a policy perspective the argument you're making about how we should interpret claim doesn't necessarily preclude someone falsely claiming something. And it does seem like the statute builds into it procedures to apply if someone does make false claims. So I guess what I'm trying to say is it anticipates that perhaps somebody isn't being completely honest in their declaration. Do you think that's fair?
So, Your Honor, I think with respect to 307, and my answer is in two parts. In the first part, turning to 307, the way that that speaks of the challenge. A VDP may be challenged, and it may be challenged for fraud. I think that someone can execute a VDP in belief that they are in fact a genetic father and be fraudulently induced into that belief. I think 307 is read as a provision by which a father who has been lured into signing the VDP on the understanding and the belief that he is the genetic father can thereafter challenge. Am I still coming through, Your Honor? I paused for a moment there. Okay. And then with respect to 302, 302 has, it does void a VDP if the VDP falsely denies the existence of a presumed declarant or an adjudicated father, but it does not necessarily void the VDP if it falsely denies the existence of a true genetic father who just doesn't fall under the definition of presumed, adjudicated, or declarant father. So there's a gap there that is not necessarily answered by 302, or for that matter, 307, when there is a fraudulent execution of a VDP. Now, I think, and the larger point that this goes to is that if you look at, there was a case cited in the briefs recently decided by the Supreme Court, the adoption of CC, and in paragraphs 35 and 36 of that opinion, the Supreme Court said, what do we do with the word apparent? Because it said you can be a presumed father if you marry an apparent, legally apparent or apparent under the law. Sorry, the exact term escapes me. And they said we could read that apparent as open and obvious compliance with law, or we could read it as seeming and suggested compliance with law. But we're going to look at the context of the statute as a whole and deem it to be the latter, not the former. If we look at the context of the VDP Act as a whole, the Declaration Act as a whole, allowing a fraudulent father, a fraudulent declarant, to gain fatherhood status has serious policy implications that the legislature could not have intended would be permissible when it used the word claim as a prerequisite to signing a voluntary declaration of paternity. So, for example,
go ahead, finish your example, and then I have a question.
Certainly, Your Honor. For example, a mother and a man could fraudulently collude to sign a VDP, knowing full well that the father is not the genetic father of the child, knowing full well that when he signs the VDP, he's perjuring himself. Under the district court's ruling, and if that ruling is upheld, a fraudulently executed voluntary declaration of paternity creates legal rights that are then enforceable under this statute against other men who may have a claim to fatherhood. Furthermore, there's no there's no best interest analysis that goes into the creation of that relationship, Your Honor. It's automatic when the VDP is executed. Whereas before, a non-genetically related male can gain fatherhood status without the VDP, he goes through the Adoption Act, which does have protections and best interests attached to it. Sorry, Your Honor, I went on too long.
No, it's okay. We have a lot of questions today, so we may ignore the clock here in a few seconds. But the question I guess I have is in terms of your argument about the policies. What about this hypothetical where we have exactly the scenario here where both mom and somebody who's not the genetic father both sort of are in on it and collude and say, both sign the VDP and say that this fellow is the genetic father, and things proceed just fine for 5 years, let's say. And then the man who signed the VDP wins the lottery, and all of a sudden has a bunch of money that he doesn't want to share with this kid. And the question then is, can we hold him to it, even though it was totally procured by fraud? In other words, if it's the man as opposed to the mother who comes in and says, "Hey, you know what? It was fraud, total fraud. We were both in on it, and I want to get out of my now putative larger child support obligations." Seems like the policies there might cut the other way, no?
Yeah. Yes, Your Honor. I think that does create a hard situation to consider. If he's not in fact a declarant father, how does that apply? Because if he is not a declarant father, under my reading of the statute, then 608 would not apply to allow the court to stop him from denying parenthood. Now, I don't think that necessarily means that the law is utterly foreclosed and the judges have to say, oh, woe is me, we can't prevent this bad act or we can't gain relief. I'm not entirely sure that there aren't parties or other claims, but perhaps they're not cognizable under this section, under this statute. But it also goes to the idea that the purpose of the statute is to find a way to enable. Statutes are designed for success, right? They're not designed for failure. In the run-of-the-mill cases, there's going to be no problem because the people who would execute a VDP in the ordinary course of business would not have much of a financial incentive to do so because it does put them on the hook for child support. And presumably they would only do so because they did in fact believe that they were the genetic father of the child and they were willing to embrace that. However, it is subject to abuse, this section, and it's subject to abuse where a mother and another man might wish to collude and hide the true parentage of the child. Now, I forget the exact case, but it was a Supreme Court case that said, we generally presume it's in the best interest of the child to be under the care, custody, and control of their natural parents. Allowing a fraudulently executed VDP subverts that. And I apologize, Judge Harris, that I have no, in my mind, immediately satisfactory answer to your hypothetical, other than to say that under the statute, I don't know that that is necessarily reachable. But that's not necessarily an argument that in this case, a fraudulently executed VDP ought be upheld.
Well, thank you for grappling with that hypothetical, Mr. Lusty. That's what hypotheticals do. They're hard sometimes. Let me go back to the. I have a couple of more questions with the indulgence of the other panelists. The statute does have a section, and I think it was Judge Pullman who alluded to it a while ago. It's 302 sub 3 that gives some circumstances under which we do declare a declaration of paternity void.
Yes, Your Honor.
The legislature there could have, if they wanted to, put another subsection, and there's only 3 of them, A, B, and C. They could have added a D. They could have said it's void if there's a fraudulent claim made of paternity and it's later discovered. They didn't. They seem to indicate that these are the situations in which allows a signatory to seek rescission within a certain number of days, 60 days. So there's a mechanism for voiding these things, and there's a mechanism for rescinding these things. But Section 307, which is the one we're here talking about, just talks about a challenge. It doesn't say what the consequence of a successful challenge is, and it certainly doesn't say that if a challenge is successful, whether it be for fraud or mistake of fact or something else, we go back and void the thing from the very beginning. I can think of reasons why the legislature wouldn't want to do that. If it's voided from the very beginning, does dad have a claim to recoupment of all the child support he's paid over the 3 years? There's some hard questions that arise if this thing is voided. And there may be a reason why in 307 there's not a statute, there's not a provision in there that indicates that if a successful challenge is made under 307 that it's voided. And so I guess I come back to the very first question I asked, which is I'm having trouble figuring out why Judge McKelvey chose the words void ab initio, because I don't think that consequence is dictated by the statute in this case. And I'm not even sure Judge McKelvey intended the result that those words engenders, because Judge McKelvey went on then to apply a Section 608 analysis, which, as I think your main argument is, look, if it's void ab initio, you don't even go to 608. Yet he did, which either means, number one, he was wrong, or number two, he didn't really mean void ab initio when he said it. So that's a long sort of question. It says, number one, the statute doesn't compel void ab initio if a successful challenge is made under 307, does it? And if I'm right about that, then help me understand again how Judge McKelvey came to the conclusion to use those words and what he maybe meant by those words.
Well, Your Honor, there's a lot to answer in that question. And if I miss anything, please remind me once I finish my answer, because If I leave something out, it's not for lack of intent, it's for lack of recall. But speaking first to Section 302, yes, the legislature does say a declaration is void in these circumstances, but I can't read that as being the only situations in which a VDP is void, or at least not effective, because 302.3 says nothing about a declaration being void if not signed by the mother, whereas 301 specifically requires it be signed by the mother. So I think that these are three situations or scenarios in which, yes, the VDP is void, and specifically void, but not the only scenarios by my reading of the statute which would render a VDP void. Now, going to the rescission aspect, I think that a rescission does not necessarily mean the same thing as void, because if we look at 306, forgive me, I had it this morning, maybe 305, but there is a specific provision that says if a VDP is rescinded, that does not mean that the declarant father or the man is entitled to a refund of child support. So I do think that there is a distinction between rescission and void that can and should be compelled. And I also think that builds into 307, which means that there is a distinction between a rescission and a challenge to the VDP, which then becomes significant. Now, admittedly, there's nothing in the statute that says if a VDP is successfully challenged, what that would do to child support, which has already been paid. Presumably ongoing, it would not be owed. I haven't really devoted too much time to thinking about child support because that really hasn't been an issue on this appeal. However, yes, 307 is silent as to what does it mean when a VDP is challenged, when it is successfully challenged. However, 201.2, Your Honor, 201.2b is not silent as to the significance of a challenged VDP. So if we look at 201.2b, subsection 2 says the father-child relationship is established between a man and a child by Roman or little b, an effective declaration of paternity by the man, et cetera, unless the declaration has been rescinded or successfully challenged. So I think what 307, and yes, it doesn't in 307 say this is the consequence of a successfully challenged VDP. It just says this is how you challenge a VDP. But 201.2b, says the consequence of a successfully challenged VDP is that the legal relationship is no longer established. And I think that is automatic. So when you have a successful challenge under 307, the relationship ceases to exist. He's no longer the father of the child. So
doesn't that sweep a little too broadly, though, right? So what's the role of 608 then? So if a successful challenge means that it's sort of always, if you successfully challenge it under 307, if the consequence of that always is a void op initio never was established from the beginning, then what's the role of 608? And does your argument apply to mistake of fact too, as opposed to just fraud? So, you know, they genuinely believe that they have a genetic relationship. Come to find out they don't. But that's a successful challenge under 307, and under the argument you're making now, that would also preclude a 608 analysis, right?
So under 307, yes, material mistake of fact is by statutory definition grounds to a successful challenge. Once proven, I think that the VDP is automatically challenged. And I think the consequence or successfully challenged. And then under 201.2b, the result of that is the legal relationship is severed. If we look at 608, and these are words that I've been pondering on for a long time. 608.1, in a proceeding to adjudicate the parentage of a child having a presumed father, we don't have that. Or to challenge the paternity of a child having a declarant father. And there's a distinction there that it doesn't say challenge the declaration of of paternity, to challenge the VDP. It says to challenge the paternity. If we go back to 2012, if the VDP is challenged, there's no longer paternity. Therefore, 608, I'm not sure, comes into play as soon as a successful challenge is mounted under 608, because there's no longer paternity of a declarant father, Your Honor.
But isn't your client's counterclaim here a very sort of Platonic form definition of a proceeding to challenge the paternity of a child having a declarant father?
So it's actually to challenge the VDP itself. Her counterclaim was brought under 307 to challenge the counterclaim on the basis of fraud, duress, which duress was not found, fraud was found, and material mistake of fact, which Judge McKelvey said on the SJ, I made a mistake, and it was in fact material mistake of fact, as Judge McKelvey found. At that point, he should have granted the challenge to the VDP, and I think that should have resolved the paternity action, because at that point, Mr. Scott no longer has a legal basis upon which to claim fatherhood.
Back to the other question. So if it seems like your argument's broad enough to sweep into it mistake of fact in addition to fraud. In other words, what you're saying is a successful challenge under 307 gets rid of paternity back from the beginning. And what that means is paternity was never established, and therefore we're void ab initio. And I guess I'm still struggling with what the point of 608 is. If every single challenge under 307 means void ab initio and you can never get to 608, then help me understand a set of facts under which we would ever get to a 608 analysis.
Sure, absolutely. So 307 limits the parties who can bring a challenge to the VDP to the signatories of the VDP and the enforcement agency. So the mother, the declarant father, and the enforcement agency. However, I do think under under Part 6, a true father can challenge a declarant father can challenge the paternity of a declarant father, even though the VDP may remain in effect, not be found to, I don't think void ab initio if it's challenged, but at least unchallenged. There's no dispute that the VDP is valid. There's no dispute that the VDP is effective, but I think a true father, a true genetic father, could still challenge his parenthood, and 608 would then apply in that circumstance.
But wouldn't 307 be the mechanism by which that genetic father challenges the declarant father's paternity?
No, Your Honor, it would be
the declarant father would come in and say, "Look, let's take a genetic test, and it'll prove that I'm the father and not him." And there's been
show he's the true father, and that's when 608 could apply, Your Honor. 608 specifically mentions we use this section specifically to address genetic testing. It really only comes into play by which a successful biological father would challenge the paternity of a declarant father, Your Honor.
fresh out of questions. So unless we're done, unless somebody else has questions.
Thank you, Your Honors. I'll hold for rebuttal.
Thank you, Mr. Lusty. Mr. Jones?
Yes, can everybody hear me okay? All right, I appreciate the opportunity to present oral argument. I always enjoy it, and I thank the court for allowing us to speak to you today. I want to go straight to this question about what does the act require or entail? So their position is that if we can call into question the VDP in some instance, then we just vacate that. That's not the case. 308 specifically requires, and it's subsection 4, in any proceeding to rescind or challenge a declaration of paternity or denial of paternity must be conducted in the same manner as a proceeding to adjudicate parentage under Part 6, the Adjudication of Parentage Act. And so this concern that somehow these parties can commit fraud and bypass the Adoption Act, it's a boogeyman, because in every instance where this happens, including this case, the court is entitled to go under the Paternity Act and is actually required to, and to evaluate essentially the equities of the party's conduct. That's how 608 comes into play. So there's always a process here, right? It's a mandatory process to evaluate the VDP, the effect of the VDP. And then even if, you bring this challenge and you call into question the nature of the VDP, it's still mandatory to go into the Paternity Act and look at all the other factors. That's how 608 comes into play. That's how it came into play here. And that's exactly what the district court did. And so, and this is supported by the definitions, the underlying definitions of the act, right? A parent relationship is the legal relationship, right? It's not defined under the Voluntary Declaration of Paternity Act or under 78B 15.1 as genetic parentage, right? And the declarant father, rather, under sub 8 is a male who, along with the biological mother, claims to be the genetic father of a child. And what does claim mean, right? Claim is to assert, typically without evidence. That's exactly what we have here. We have a VDP where both parties, again, not just my client, both parties cooperate together to claim that he is the genetic father. And so that starts the ball. Now the process is initiated. And Ms. Benson could come in and say, look, this VDP fails the test of the act, right, under 302. It misrepresents the status of a presumed or adjudicated father, right? We don't have that here. That's unequivocal in the record. Or she could say, I'm going to rescind it. Again, we don't have that here. She didn't act in time. That's inapposite. Or
yeah. So do you think that we get to 608 if we're in one of the subsections of 302.3? In other words, if the declaration of paternity is void under 302.3, do you think there's an opportunity for a trial court to engage in the 608 analysis?
I do, because as I started in my argument, right, under 308, in any proceeding under rescission or challenge, that inquiry is mandatory, right? And so it's interesting because there's some adjectives in the statute, valid declaration, effective declaration, that Mr. Lusty pointed out. And I think that there's at least some argument that maybe if a VDP fails under 302, those adjectives matter, right? Maybe the VDP suffers from sort of some underlying infirmity. But even if that's the case, right, I think the legislature was very clear in requiring that whenever we're dealing with rescission or challenge, right, the VDP itself is not the dispositive question. The dispositive question is the impact on the child. That's why the process
used the word void in 302, didn't use those terms in 307. You think, in other words, Mr. Lusty thinks it's all one thing and you think it's all the other. You don't think that there's any distinction to be drawn between voidness and rescission in 302 and 306 and then 307 that just talks about a challenge?
I don't know. I think it's a fair question, because there is this, sort of straight statutory infirmity. That's not the way in which this case arises, right? Ms. Benson never said this VDP fails to meet the required elements of 302, right? She came in under a raw challenge section, 307 challenge section, as Mr. Lusty acknowledged just now. But so I think there is a context in which this could matter, right? When the parties misrepresent the other, an adjudicated or presumptive father. And that makes sense from the broader context of the statute and the public policy of the state, because what we don't want is people coming in and executing a VDP out from under somebody who also has potential rights in this circumstance. And as you noted, Judge Harris, the VDP scheme allows a presumptive or a adjudicated father to participate. There was never an underlying misrepresentation about his status one way or the other, so it doesn't serve to operate in this case. And yes,
I need a little bit more help in understanding how 608 is invoked here, because 608 specifically is talking about denying a motion, seeking an order for genetic testing, or disregarding genetic test results. Yes. We didn't have any genetic testing here, right?
That's true.
And so although, I mean, I get why you can kind of by analogy say, well, maybe this should apply. I mean, this is a very specific provision talking about genetic testing, and we just don't have that in this case. So how is it that 608 is invoked at all?
Well, the Ms. Benson below did move for genetic testing. So in the trial court record, it happened, I think, the order of November 15th, 2019. Prior to that, Ms. Benson had moved to force genetic testing in order to essentially establish the non-genetic relatedness of Mr. Scott. The parties resolved that as has always been acknowledged, stipulating that he is not, in fact, the genetic father. So while we don't have genetic test results in this case, an effort was made to secure those, and it was resolved via stipulated acknowledgement that he is not the genetic father. So I think it's a fair question, in relation to the statute, but is the way this case developed, right? The practical impact here is Ms. Benson sought to disprove Mr. Scott's genetic paternity. That's acknowledged. Genetic testing results were not necessary. So I think that 608 still applies, because in any action, right, when we're evaluating this under the Parentage Act, the question then becomes, well, should genetic test results be disregarded, right? And here we know what the genetic test results would say. Those are stipulated. So the question under the statute still remains, ought that genetic unrelatedness be disregarded? And here, again, the statute is very clear. There is a process to evaluate both parties' conduct. So I still bristle at this idea that ex-boyfriend is the one committing fraud and he's the bad guy, because they both participated in this. And that's exactly what happened. The district court said, look, Ms. Benson, I'm going to, you might be able to say that the VDP is voidable, perhaps, on some level. I believe that that's what Judge McKelvey was trying to say when he used void ab initio. Or as I asserted in the briefing, he was asserting, look, you have met a statutory element. You might be able to prove fraud that's material, right? Nonetheless, the process requires me to go over here to the Parentage Act. And in the Parentage Act, I find the opportunity to disregard genetic testing. But I still have to make findings. And those findings are here that you wanted this result, Ms. Benson. You participated in this. You also signed the VDP. If the record was established that you wanted Mr. Scott involved as the father in case something happened to you, you did, in fact, allow this man to operate as the father for 7 years of this child's life, right? And only when it became expedient to you to withdraw that did you change your mind, right? And so she is stopped. That's the whole point of the statute. Oh, sorry, Judge, I didn't realize you were raising your hand.
Yeah, you're getting into the 608 findings, which aren't really challenged here. That's not really the point of the appeal. So I want to try to get back to the void ab initio question, which is really the crux of this in some ways. Do you know why the trial court picked that language? And were the parties asking him to use that phrase? Can you shed any light on the genesis of his use of that phrase?
Yes, frankly, I think it came out of the blue. I don't recall anywhere in the record where Ms. Benson asked him to rule that it was void ab initio. In fact, his prior ruling evaluating this, he found, look, she participated in this. It's not a mutual mistake of fact, right? It's not, I'm going to deny this challenge. And sort of post-trial, he sort of abruptly changed course and then came out with this void ab initio language. But I think, and I try to address this in the briefing. If you read that in context, he follows the statute. He looks at is this rescission? No. Is it a mutual mistake of fact? Not necessarily, right? Is there potential fraud? There might be potential fraud on the Office of Vital Records. There's certainly not fraud on the court, because neither party ever misrepresented what, the genesis of that was. And then he said, okay, so I could find, or I'm finding that the VDP is void ab initio. But as you pointed out, if he had found purchase in Ms. Benson's argument that was somehow dispositive under the statute, he would have stopped. He would have said, the VDP was void, there's no access to the act, the end. He didn't stop.
Right. There's some simplicity to the argument that Mr. Lusty is making. That is, if it's void ab initio, then he really was never a declarant father. Even if he complied with the statute, with every T crossed and every I dotted, if you void that thing from the get-go, then how can you say he's a declarant father? I mean, that argument does have some simplicity to it. But
Yes.
What I'm struggling with is in 307, what is it an option for the trial court? I mean, does the trial court have the option at that point to say, I think your 307 challenge is successful. I'm either going to A, set it aside void ab initio, or I'm going to set it aside sort of going forward, so that I'm not unpacking anything that happened in the past, but I recognize your challenge is successful. Starting today, I'm going to set it aside so that there's no longer a parental relationship here. And those are two very different things. And the statute doesn't say to the trial court that he has to do one or the other at that point. And we don't have anything here to sort of grapple with as to what the trial court was thinking on that point. And that very well might be totally dispositive here. So what do we do with that? You talked in your brief a little bit about how, hey, I couldn't appeal the void ab initio, and so do we have the benefit of your thinking on this?
So yeah, my position in the brief is that it doesn't matter, right? So look, I understand the allure of the simple argument, but just because it's simple doesn't mean it's correct. I think that what you're saying, Judge, is fair. I think the statute gives the district court, the fact-finding court, the prerogative. If the circumstances surrounding the VDP are such that it needs to be invalidated from the outset, I think potentially under 307 that's available. It's not mandatory based on 307's language. I think that if the court wants to go further, that absolutely under the process that is mandatory, it asks the district court to evaluate it as any other proceeding under the Parentage Act. And this goes back to what I was saying before. The simple answer isn't the correct one here, because the VDP and the operation of that in even a vacuum, not a vacuum, but even in isolation, is not the dispositive evaluation. The statute requires these district courts to look at the impact on the children, both of mother's conduct and of the declarant father's conduct. And that resolves all the hypotheticals that you pointed out. So if we have an example where a father signs a VDP with a mom, then wins the lottery, and then tries to disavow his parentage, he would be stopped under the statute from doing so by virtue of his conduct, right? And
he's stopped under 608, but Mr. Lusty's argument is you don't even get to 608 if there's never a declarant-father relationship in the first place.
And that's right, but I think that if you do that, if you adopt that interpretation of the statute, then it obviates everything else. So it would, if this was what the legislature intended, it would have 302. Right, as these are when a VDP is void, and it would have some sort of clear pronouncement that a fraudulent misrepresentation about genetic parentage is, voids it, right? Or it would have some sort of language saying, when rescission is proven or when a VDP is called into question, there's a mistake of fact or fraud, right? Then the end, just like we see in the rescission section of the statute. We don't have that, right? So the legislature asked these district courts to do more in this case because it recognized the impact on the children, right? It recognized that these are the children are the people in the middle, and their interests are what needs to be safeguarded. And the equities of the party's conduct or their engagement is what matters relative to that inquiry, so that the children can be taken care of. Yes, Judge Pullman.
But the legislature also uses terms like declarant father in 608, right?
Yes.
And if something is void ab initio, it is though it never happened. He never declared his paternity. He never declared it.
Yes.
So I'm having a hard time understanding how it is that he fits into 608 once the court declares that declaration completely void and as though it never existed. It's as though he's just some random stranger to this event, and all of a sudden we're supposed to evaluate whether or not it's good for him to be with the child.
Potentially. That's not what Judge McKelvey found here, but this is where CC matters, that case. So they void the status of the marriage because it's bigamous. The district court does, right? The Utah Supreme Court comes in and says, look, just because, and the district court used void ab initio in that case, right? The district court said, look, that's not appropriate because, the statutory section says married in apparent compliance with the law. Well, here we have a very similar exception. We have the 608 exception, which is a mandatory evaluation, essentially. Well, getting to part 6 is mandatory, and then 608 is permissive. It's available to a district court under circumstances, right? And so we have the same exact type of section here where there's an exception, right? When these threshold considerations are met, right, that status, even if arguably questionable from its genesis, doesn't change. And
but it's not arguably questionable. That's the problem. You've got to take that word out, right? It doesn't exist. because once he's made that determination about void ab initio, it doesn't exist. So it's not an arguable, it's not, maybe it was there, it's gone. That's where I'm struggling here.
Sure, and I understand that, but McKelvey, I don't think that's McKelvey's ruling doesn't indicate that's the way he viewed it because he proceeded, right? If he was going to make a determination that it's void ab initio, that would have ended the inquiry. He didn't. And
I agree with you. Like what he did doesn't suggest that's what he thought,
yes.
But he did use that term. He declared it void ab initio. And don't we have to undo that declaration before we can agree with what you're saying here?
I think so, because CC did the same thing. The Utah Supreme Court said, you declared this marriage void ab initio. You don't get it, that status doesn't change because there's a statutory exception. And here, going back, McKelvey went exactly to the statutory exception available here and made the requisite findings, which are unchallenged, which allows this court to uphold his ruling.
But the way I read CC, it's all about that apparent compliance with the law, right? If this said an apparent declarant father or something like that, we would be in a totally different situation. And I think CC might have been ruled differently if it had just been whether or not there was a marriage, right? Period. I'm not sure the Supreme Court would have reached the conclusion it did. So I just feel like it's a completely different situation than what we've got here.
And that may be one way of viewing it, but I think that the Supreme Court was informing the trial court that, look, when you're evaluating the statute, right, there's this, you have to look at this language and what it means. You have to essentially abide by the language and give it voice. And Ms. Benson's argument doesn't give 308 or any of the procedure sections voice. It just sort of obviates all that, in favor of reading new requirements into earlier sections of the statute, right? CC is important here because it informs us, especially for the purposes of appellate review, that we look at this district court, where this district court went with its other findings, and it made the findings necessary under the statutory exception to disregard genetic test results and to stop, and this is where I know, this goes back, but to stop Miss Benson from mounting the argument. And that's what's important here. She was stopped from her challenge by virtue of her conduct. So I would submit that we don't even get to the rest of this because she was prevented from denying parentage in the first instance. And that part is not challenged on appeal. No other questions. I appreciate the time that the judges have devoted to this case. And again, I thank you for giving us an opportunity to speak with you directly today.
Thank you, Mr. Jones. Mr. Lusty?
Thank you, Your Honor. Just a few notes. With respect to the challenge provision, my colleague argued that Section 608 should allow an estoppment to a challenge under 307. But there's no language under 307 suggesting that estoppel should apply when a challenge is being brought. The estoppel language only comes into play under 608. If that were true, 608 would overrule 307, which would not be an appropriate statutory construction that I would submit. But also looking at Section 308, my colleague has argued quite extensively that Section 308 somehow proves that Section 608 must always come into play when there's a challenge to a VDP. But if you look at 608, particularly the last subsection, it says a challenge may be brought in a manner similar to an adjudication of parentage. It doesn't say under Section 608, it just says in a manner similar to it. I think the best way to read that particular provision is that you have to file a petition, you have to name certain parties, you have to effectuate service. Genetic test results under Part 6 would be applicable. So I don't think Section 308 really adds much to the discussion or should to the decision. Finally, with respect to, well, I shouldn't say finally, two more quick matters. Judge McKelvey used the term void ab initio. We can presume that a district court judge knows what the term void ab initio means and intended it to be void ab initio. That's illegal.
As opposed to just setting it aside as of today forward. And we don't have any indication in his ruling as to what his thinking was on that or why he chose it. And you don't think that's a problem?
His ruling referenced fraud, reference to fraud on the Department of Vital Statistics, not fraud as against any of the parties. I think that the fraud that Judge McKelvey was holding as taken from his ruling is that the whole the whole VDP was fraudulent, that it, from the beginning was fraudulent. There's not fraud arising subsequently to its execution, that it from the beginning could not and should not have been executed by these parties in these ways, which does, in my mind, support a void ab initio finding. And if I may briefly conclude, Your Honors, the fact that the genetic father has unfortunately passed away is the sympathetic fact to Mr. Scott that makes affirming his, in this case, dangerous. Because although there is no genetic father or biological father whose rights have been supplanted or suppressed by the execution of this VDP, upholding a fraudulent execution of a VDP will allow a genetic father in the future to have his rights abridged, challenged, and it will create mischief in the way courts.
Your arguments today, they were incredibly helpful. This is carefully and we appreciate how carefully you have prepared and argued. And your briefs were also excellent. So thank you very much for your good work. We will take this matter under advisement and